Well, what it does hopefully do is allow us to incorporate the thoughts of the Waitangi Tribunal into the thought process that the government is having. We gave an indication to the tribunal that if we didn't receive the information by August the 24th, that made a potential sale of those shares in 2012 more challenging for the government. So it's great news that they are looking to accommodate our wishes, and we look forward to seeing their interim report and then factoring that into the overall decisions that the government makes. Yeah, I mean, look, we sought advice before we went and asked them whether it was possible for them to report back on the 24th of August. We didn't receive any advice from either our QC or from Crown Law that there was anything inappropriate in us asking for a date a little bit earlier. They had indicated that was likely to be in September, so there wasn't a lot of difference in the timing. It just suited our timetable a little bit better. And we are very hamstrung by the fact that we can only take Mighty River Power to the market at times when there's audited accounts, so we don't have lots of flexibility, and they are literally October, November this year or March, April of next year.
How much would it cost you if you couldn't take Mighty River Power to list it this year? What would it cost you in interest payments on the debt?
Haven't got another calculation, but if it's in the order of magnitude of less than a couple of billion, but more than one, you can apply the interest rate for 6 months that the government borrows. It's a lot of money.
In regard to the process, the tribunal does say it's most unusual and inappropriate for the council the way it's acted for the Crown, and reminds the Crown about the need for judicial independence and maintaining separation of powers. I mean, they're quite strong statements.
Well, as I say, we sought Crown Law advice and advice from David Goddard, QC, and neither of them were of the view that there was anything inappropriate in what we were doing. I mean, we've made it clear that if they can't accommodate our timeline, then we'll appreciate that. But we were just simply pointing out that there was reference in their initial findings to us that a submission made by Treasury on behalf of the Crown seemed to have indicated to them that we weren't under enormous time pressure and therefore September would be okay. And in fact, we are under a time pressure for the reasons that they may not have fully understood, and so we're simply pointing that out.
There have already been criticisms about good faith. Do you not think this feeds further into that and potentially compromising the process?
Well, quite the opposite. I mean, we're demonstrating tremendous good faith by wanting to get their report before we actually make any decisions, and therefore factor their report into our findings.
Would it be fair to say that government has been kind of stiffening up its legal case should an injunction or an attempted injunction come about?
Sure, I'd characterise it in that way. What I would say is that over the last 3 or 4 years, the government's view has been that it needs to address the issue of water rights. We've been doing that in a variety of different forms, Land and Water Forum being one, the direct settlements and negotiations around rights and interests that we've had with Māori, and we're very confident about our legal position and that we are following the right process. We're also mindful of the fact that it's eminently possible that an action may be taken by someone, and therefore we'd need to defend our position in court, and we're confident that we've followed the right and proper process.
Presumably, if the government was to act contrary to recommendations of the tribunal, that wouldn't be helpful to any injunction. I mean, there must be some advice on that. It's not going to be helpful for you if my compromise.
The Crown has in the past acted against the advice of the Waitangi Tribunal. Obvious example of that was around Kupe and also in relation to, I think, oil and gas. There's also a 1990 case in relation to when the Crown wanted to sell broadcasting rights on the 1st of December. They were taking that, the Waitangi Tribunal indicated that they were likely to report back, I think, in the early to mid part of December. Crown actually decided it wanted to press ahead before it got that report, and the High Court upheld the injunction and required the Crown to wait for the advice because it was very close. So there is some sort of precedent there, but in this case, we think it's good news that the Waitangi Tribunal has indicated that they're likely to give us that information on the 24th of August. It helps our process. Still a very tight process for a 2012 sale. Subject to a whole lot of other things that might flow from that.